Come on, please.
Oh.
As the case is the court was the state is calling case number D794 of 2020 for the state versus Ratlehile Edward Moerani on record today, the 28th of June 2024, in the Magistrate District of Rustenburg held at Rustenburg. The court composition, presiding officer, Mr. Diari, public prosecutor, Mr. Matalani, our interpreter is Ms. Dubuva, our stenographer is Mr. The accused is legally represented by Ms. Tomben. Worship is Schedule 5 of truth, bail application.
Your Worship, I confirm my appearance on behalf of the applicant. Also confirm, Your Worship, that it's a Schedule 5 bail application. Your Worship, we have prepared an affidavit in support of our bail application and on the first reading it shortly.
Yes, ma'am.
Your Worship, it reads as follows. In the Magistrate Court for the District of Rustenburg, Rustenburg, case number D794 of 2024, in the matter between Edward Applicant, Moerani, my previous Worship, affidavit in support of bail application. I understand Edward Moerani Applicant, hereby making oath and state the following. The contents here or say or otherwise indicated are well within my personal knowledge and to the best of my belief both true and correct. The provisions of section 611B paragraph A have been explained to me by my attorney. I understand that everything I said in this affidavit is admissible as evidence in any subsequent proceedings. I understand that I'm obliged to fully disclose all my previous conviction and pending cases, and that failure to do so or supplying false information in this regard is a criminal offense punishable by a fine of 40,000 rand or 2 years imprisonment or both the fine and the imprisonment. I also understand that furnishing in false information in a bail proceeding that might affect the decision to grant me bail and may result in the subsequent cancellation of my bail and my return to custody. I am an adult male, 29 years of age. Presently, I'm residing at house number 1A, Ward Street, East End, Rustenburg, for a period of 10 years. I have no alternative address. I'm a born and fide South African citizen. I do not have relatives or friends outside the Republic of South Africa. I own the following assets, only household furniture. I am employed at K6 Shaft next to Ramachana Prison. I've been employed for a period of 1 year. I earn an amount of 6,500 rand per month. I am unmarried with 3 minor children, namely Unity Zani Molebangwe, 2 years of age, Stan Molebangwe, 8 days old, and 1 who is the deceased son. I also provide support, food, clothing, and shelter to the following persons who are dependent on me: my partner, Makato Molebangwe. Consequently, my continual incarceration will be financial prejudicial to them as I'm a breadwinner, and this case may only be finalized after a long and extended period of time. I understand the charge against me and I understand the nature thereof, to which I intend on pleading not guilty. I know if convicted, the sentence to impose might be severe. I'm not a flight risk and I intend that I will not flee or evade trial. I do not harbor any resentment to any person involved in this matter, and I will not interfere with state witnesses and or the complainant, and I will not attempt to intimidate witnesses or conceal or destroy any evidence in this matter. I did not supply any false information to the police at any stage, and I commit myself to cooperate fully with the investigating officer at all times. With regard to previous convictions and pending cases, I have no previous convictions and I have no pending cases. My release on bail will not jeopardize my safety and the objectives and the proper functioning of the criminal justice system. Consequently, I accept any other conditions which the court may attach, and I can afford bail in amount of 1,000 rand. I therefore humbly submit that, taking into account the aforesaid, that it will be in the best interest of justice that I be granted bail. And the reasons that justify my release on bail are as follows. I want to be released on bail so that I can assist my family to bury my child who passed on, and relatives and apologies to my other family members and my partner, who is the mother of the deceased child. I have been residing with the mother of the child for a period of 10 years. She is unemployed and depends on me. Should I be detained further, my family will suffer financially. And I also want to assist with the funeral arrangement which will be held this coming Sunday. I am on chronic medication. I have been taking the said medication in the boarding cells. However, the diet does not meet the standard. I am not safe at the boarding cells. People are always fighting, and when I report to the police, they do not assist. I stand to lose my job should I be detained further. I am employed, but my school is not a scarce school. I can be replaced anytime. Without dwelling into the merits of this case, I did not plan to cause the death of my child. It was an unfortunate incident. Your Worship, this statement was signed and dated today, the 28th day of June 2024, by the deponent as well as the deponent's legal representative, and it was duly commissioned by the Commissioner of Both Worship. And Your Worship, we humbly request to hand the statement after the confirmation by the accused person that he acknowledged the contents of the affidavit as well as that he has signed the
Do you confirm the contents of the statement as read by your legal representative? The statement of the applicant is marked Exhibit A, submitted to record.
Because this is Your Worship, that will be the applicant's case.
When you said he wanted to apologize, is he admitting committing this offense?
No, Your Worship.
No. So why is he apologizing?
Your Worship, even if there are allegations that I spoke something or I killed or it's an African way, Your Worship, to apologize to those people to say, I'm sorry.
So, I don't understand. If you are innocent, if you are guilty, it's African to say I'm sorry even though you know that you are innocent.
Your Worship.
Is it where you are going?
No, Your Worship.
Yeah.
Your Worship, there's a child who passed away.
Yes.
And the allegation before court is that the accused person has killed the child. Those are the allegations before this court. The accused person, Your Worship, when they then, Your Worship, even other accused person will appear before court with an allegation that they have killed someone in the family. Even when they do not kill, they go and apologize, Your Worship. Some even offer those family members money to assist with burying the child pending the finalization of the court to decide whether this accused person is guilty or not guilty.
How is he going to plead to this offense?
He will be pleading not guilty.
Not guilty.
Yes.
Thank you.
Court decision.
Yes, people. Is that the applicant's application?
That's the applicant's case.
As it this is the proceedings for the respondent's case, the state will be calling for common basis.
What is your name, sir? Do you have an objection in taking a prescribed oath? Do you swear that the evidence that you shall give shall be the truth, the whole truth, nothing but the truth? If so, raise your right hand. So help me God. Yes, people.
As it this is the court, Your Worship. So do you confirm that you are the investigating officer in this matter?
I confirm.
Now, say the applicant before court, Mr. Rustenburg Edward Moerane, has brought an application to the listing bay. Did you verify the applicant's criminal profile? Does the applicant have any previous convictions or pending cases?
According to the line that I have in the script, it doesn't show that he has previous convictions, but he told me that he has previous convictions.
And does the applicant have any pending cases?
No.
As I've indicated that the applicant has brought an application to the Rustenburg. What is your attitude?
I object that the accused person be released out on bail.
Can you kindly advance present to the Honorable Court why you are saying that the applicant should not be released on bail?
You may sit down, sir.
I understand that it is right to apply for bail and then be granted bail according to the law of South Africa and the Constitution. But the incident that has occurred is very hurtful, and also it happened that this child is not the applicant biological child. It shows that the accused person is a very abusive person towards children. According to my investigation or my research, I found out that the accused person is being abusing the deceased child. It was not the first attempt. Your worship, that happened a day before he killed the deceased child. It happened that on that day he had beaten up the child. He assaulted the child and then pushed the child. He assaulted the child and then pushed the child towards the wall. It happened that the child acquired injuries.
When I did my investigation, Your Worship, I found out that he had assaulted the child because the child had bathed and also washed the child also washed the underwear.
And then I really
And then after washing that underwear, he wore it again.
and still see the kupisa mola za dibomo kuma shotota aba update out.
That offended the accused person a lot, and then I end up assaulting the child.
Le tadile la tela no atuka ana yaka icho ya ma kumula kushona ya mbele.
According to the mother of the accused, on the following day he went to work.
Atukela bana baba bili 11 years, they were 10 years.
He went to work leaving behind two children. The other one is 11 years, the other one is 10 years.
So kila mo kampore ineli tumalano ya bone ya ka kapu ore bana bao bata sala bana ba di mula kutwa ayako.
According to them as a couple, it was their agreement that the children will be left there alone when the accused person is going to work. Without any elderly, without any elderly people taking care of them. During the day, the child who is 11 years the one who's been killed. He then had injuries, and then he was in pain, but afraid of the accused person. He decided to pack his bag and leave the house.
And then a person who was passing by spotted the child, and then he asked the child, according to the child, he was going to his uncle. He asked that person to assist him to cross the road. That person decided to call the mother, since that person knew the mother, but the child would explain to that person that the father had assaulted him the previous night. And then the child was taken to a friend of the mother of the deceased child. The mother then called the accused person, and then he told the accused person that the child had moved out of the house. Then he doesn't understand why. Then the mother instructed the accused person that whenever he gets to the house, he must take something and give to the child. Then the mother of the deceased child told the accused person where the child is at. The accused person that is supposed to protect the child went there, and then when he got there, he dragged the child, pulling the child back to the house where the child had run away from. Even on his record, Your Worship, he recorded the child asking for forgiveness. The child was in fear. You can hear from that recording, Your Worship, that the child was terrified. He was in fear of the accused person, and then the accused person continued to assault the child further. After Your Worship, he assaulted the child. He continued to assault the child. After he sent messages to the neighbors saying that he's shocked the child is not breathing. I'm asking myself what was his shock, because he was the one who was assaulting the child. The community members and also the community leaders tried to enter the yard where the accused person locked himself in. Two of the community members jumped the gate or the yard to gain entry. After they gained entry, the accused person assaulted one of them by hitting him with a fist on the eye. That person was so late, I saw that person. He was very furious.
And then,
after that, they called us as the police. When we arrived, we found that with another person in the yard. When we asked him what happened, he told us that he was assaulted, he was beating the child, then the child stopped breathing. The other one is 2 years.
pero ga na ke ga ya mo go tsa go tsa gore a ka na tsa na
because when by the time the 2-year-old child woke up, it was the time we were leaving, and then we had already processed the scene. I was wondering what he had done to the 2-year-old child
ga go wa le se ba le se
for such a long time.
bone ga go bona go na le se se
I also spotted a bottle of benzene that was nearby.
so ke tsa gore monna o ke a kana go bona gore ke use ya ba
I can notice that the applicant is an abuser of children.
ko ke go
He's very dangerous towards children.
ga le go tla ka mo tsa ke tsa gore go na le case number
When the court would grant him bail, I take it that there's no place that doesn't have children.
ko ke tsa gore ga a tla go go na ba
I take it that there are no children in the cells and the custody.
se sengwe le gore community leaders le members ga ba kganye a ya ba jesa mona ke sa itse gore ka na le kgatelesego ka mo tlhakisetsa koo kapa le ene a lwa le bone a fetsa mara a bontsha dipaki tsa se tsa diteng
Also, Your Worship, the society and the community leaders are not pleased with this incident that has occurred. I don't know if he's to be released on bail to stay because he doesn't have any activity affairs.
a le mo sa le mo tiragalong ya le se o sa ntanta dikganyetsa
Your Worship, even he's not even remorseful or humble about the incident that he has done. He's refusing or denying what he has done even today.
ka jalo ke tsa gore so a ka se boeletsa ka nako nngwe
I take it that he could repeat it at any given time.
Yeah, but there are some issues that need to clarity. You said, where was this deceased body found?
o kry-ile mo kgorong ya ntlo ya disease o nna mo bekong mo monyako mo o na diwa slide mo madi a tletseng a bonala na le assault into bona o na bekwa
The deceased body or the deceased corpse, Your Worship, was found in the accused person's room. He's renting a bedroom, Your Worship. He's staying in a bedroom. The deceased corpse were lying down at the door. There was blood and also wounds showing the injuries.
Was the body taken for any forensic or to determine the cause of death?
ka lesego ke ne ke ile ko postmoteleng ngwana o biditswe mo tlhogong and then madi a a stopa dithekiso ka doctor o na le di-wounds tse mmeleng tsa go bontsha gore
Your Worship, fortunately, I went there for the postmortem, Your Worship. According to the postmortem, the child acquired injuries in the head that caused bleeding inside and then into the brain, Your Worship, that made
there were wounds in the body of the child, Your Worship.
Yes, PP.
Okay,
ka o rialo ke community le one ga ya itumelela so se se diragetseng mme le ene mmaagwe ngwana a ke mmotsa ka se se diragetseng o bontshitse le ena se itumelang ga re ka itumelela gore a batlile ka
also, Your Worship, the other point is that the community is not pleased, and also the mother of the child is not pleased. She doesn't want the accused person to be released out again.
gape bontsi ba dipaki bo dula teng mo strateng sone se a reng ke one ateresa se a leng ateresa ko go ga bone ga se a reng ko go ga
Your Worship, also most of the witnesses are saying in the same area where the accused person is residing. The accused person is not renting as his parental home will be staying.
So what alerted the community to come and really inspect it? It is what was happening.
ene a sendela one of the community members SMS a ba a re ngwana
One of the community members by sending an SMS telling that person that the child is not breathing.
ene le mo voice recording ya ka ne a bua le the girlfriend or girlfriend ga yo ko magae so ga ba bua di communication ko tsotlhe bo gore go na ya go mmetsa ga mmetsa o mo tlhalositse gore go ja mmetsa gore communication yo ke teng mo
And also, Your Worship, there are recordings of sending voice notes to the mother of the deceased, telling the mother that I'm treating the child now. Everything was recorded, Your Worship, is there in the phone.
So how far or how long is your investigation going to take, or have you finalized the investigation?
The only thing that can take longer is the DNA results, 3 to 4 months.
Is there any history of abuse between the deceased and the applicant? Is that the two incidents that happened?
ga ke botsa mmaagwe ngwana o ntsetsa eng ka nnete
When I asked the mother of the deceased child, she said yes, he usually assaults the child.
But are you then taking any action against the deceased mother? Aren't you taking any action against her?
eo ke yone sentse re go e bua le botšhotšhisi ka gore ke statement fela but botšhotšhisi le tlo go e buisa
So I see that the accused person is facing 2 counts, one being murder, the other count being assault. Is this assault pertaining to a member of a community who came to investigate it was happening?
No, it's an assault which happened, I believe it's an assault which happened the previous day, on Thursday, because the incident happened on Friday. That's a particular, the murder happened on Friday. Then the assault happened Thursday when this boy went and reported.
Yeah, because what I'm hearing here is that the name of the person being assaulted is Itumeleng Joy.
Oh, okay, no, I was not aware. I thought it's only about
The child.
the child.
So this Itumeleng is one of the community members who was
He
also.
mentioned on the statement that he was assaulted. Yes,
Thanks for that clarity.
And this Itumeleng Joyce is also a witness in the murder case, in the murder charge. Is that correct?
Yes.
You mentioned that you like to assist with the burial of the accused, of the deceased in his affidavit. How does the family of the deceased feel about the incident which occurred?
nna la bofelo ke bua le bone ga ba itumele gore monna wa ka tloga.
The last time your worship had a conversation with them, they are not pleased, and then also they are objecting that the accused person didn't start anything.
Is there anything else that you like to tell the court that you feel like the state did not ask you with regard to the applicant's bill application?
Yeah, as you may have seen, I'm not doing anything.
Your worship, Martin said that there is something the court would allow our voting.
Are you done? Cross examination.
But have there been any cases that were opened against the accused person before?
No?
You indicated that the mother of the child is the one who gave the instruction that the accused person assault the child.
Yes, that's true.
Where are we going with that question? Where are we going with that question?
Your Worship, we remember the court asked us the reason why we are approving the statement.
Yes, ma'am.
That's the reason why we're asking that we wanted to clarify the issue. And you mentioned that the community members would have a problem that you have you received any petition or any there's another child in that house or the other children in that family, are there any communication or anything from the family indicating that the accused person was assaulting these children?
Go na le elimetso e leng gore o kry-ile kgotsa puo e leng gore e leng gore e tswa mo familying e thusang gore mosadiwa o kile a ketsetsa bana ba bangwe ba le ba bangwe ba babedi Is the mother of the accused person on one of the mama who that is of the is that the mother of the deceased told me that yes, indeed, the accused person was the mother of the deceased should be told me that it is the accused person indeed has abused the children people.
The accused person indicate that he will not, his life will not be in danger should he be released out of jail, but will be in danger should he be kept at home.
I'm not denying what he's saying, Worship, but I'm also saying that the lives of the children is complicated.
And that should he be kept in custody, he stand a chance to be injured and possibility of being killed, because there's always fights in the whole society.
Your Worship, according to my knowledge, there's all police officers at the holding cells who are appointed for the specific holding cell. I've never heard that there are no police there. And then if he has a complaint, he can take it out to those police officers.
Then there is no likelihood that should he be released out on bail or commit anything or one of them.
I'm not certain about that. If the accused person could assault a child for wearing a wet underwear, I'm not certain that he was not commit any Schedule 1 offense or abuse the other children.
That the accused person will not evade his trial because he's residing within this court area of jurisdiction and employed within this court area of jurisdiction. children are not safe. How many children are in that house?
bana ba gagwe le babedi ba ile go na le bone ba ba di mo but le na counter is okay
Your Worship, he has two other children with the mother of the deceased child. When he committed this offense, the other child was 2 days old.
And will you agree with me that as we stand here today, those two children are no longer at the said address where the alleged incident occurred?
Ya ka re bua ge ka se ba dumelana le nna gore bana bao ga ba ka le teng le ke e bua ka yone e go mo go sa bua go na go teng
bana bao ga ba mme kgang ga se ka ga batho bao ke bana ke dilo go ba tsa mo Afrika ga ntse go bana ke se ka bua a mo ka mo go ba
That's not in dispute that the children are not there, but the actual fact is that there are children in the community. You'll be passing by children every day. You don't know what triggered him to kill the other children, the other child, the deceased child.
But the applicant have been passing children for the past 29 years, and they have not been any report to the police that he killed or assaulted any child until this alleged incident. And before you respond, I want to read to you that that's a proof that he's not a danger to children or any other community, any other children that are in the community.
mme fela ga kgona go dira seo seo mo ngwaneng wa thutong gore a mo sireletse mme o neng a mmona ebile le bo recording a ba mmitsa papa even though e se papa a gage le bua madi so motho o ntsenyana ga o kwa re ka tshepa sepe because le ene gore ga se ngwana so le ba bangwe ba iseng ka madi.
Yes, I can hear you, but the accused person, the child that he assaulted, he also didn't father that child. He's not the biological father of that child. So also the other children in the community are not his children. But if he could do that to a child that he's supposed to protect, and then you could hear from the recording that the child was calling him dead. I don't trust that he would not do it again.
And will you agree with me that bail condition on this applicant before court will be possible for the court grant the accused person and put bail condition. It will be possible for the accused person to adhere to bail conditions. Am I correct?
Bail condition ke mokwalo ene anong ga re bua ka protection ya motho re bua ka physical seo ke mokwalo e leng gore pele ga itse gore a o tla go banela gore ga kitla e bontsi ba beela di-bail conditions ga itse ba so ka se ka netefatsa
bail condition is something that is written, but protection is something that is physical. So many broke or contravened the conditions.
Has that, are there any protection order against that person, or anything that, any order of the court against that person? Harassment order, protection order?
Order if the protection order, it's a harassment order. No?
With regard to should the accused person, you indicated that witnesses are residing in the same street as the accused person. And you indicate that, I'm not sure if you, I apologize. Yes, the witness said something about the same kind of, like they are residing on the same street, the same accused.
And they are faithful of him, shall we say. Yes, defense. How many questions still remain?
My question is, you mentioned something about, you mentioned that the witnesses are residing within, in the same area with the accused. Has there been any complaint from the witnesses that since the accused person has been in custody, has been trying to, I put it to you like, okay, my administration. So have there been any complaint from the witnesses or any other person that since the accused person is in custody has been intimidating them?
I think that he's in custody, there's no way that he can go to
So there has not been any communication with the witnesses since the time from the accused person.
Communication
I think that the witnesses cannot come to the accused person, and then also that the accused person only has access to communicate with his relatives or his family. Yeah.
And should the accused person provide you with alternative advice or you still oppose application on the basis that he's staying next to the witnesses and
Yes, this is not about where the accused person stays. It's about the children and the safety of the children.
we have no further questions.
Thank you, sir. You're excused there. Yes, State, do you have any other witness?
No, Your Worship, that is the respondent's case.
Are you ready to address?
Yes, Your Worship, we can address.
Yes, because if you address today, I think by Monday or Wednesday I'll be ready to give my judgment. Yes, sir.
Court cases, Your Worship. Your Worship, we submit that the interest of justice can be that the accused person never released out of the Worship. Your Worship, the accused person have testified through an affidavit to inform the court of the reason why you want to release out on bail. Your Worship, that which will not repeat into record as we have already submitted the affidavit. Your Worship, we submit that the accused person will not evade trial in this case. He is a resident of this Honorable Court, Your Worship. He has been residing here for the period of 10 years. The address where he is currently residing, Your Worship, belongs to his current Your Worship. He informed the Court, Your Worship, that he does not have any alternative address that he can currently relocate to. That, Your Worship, he will not interfere with witnesses and complainants in this matter. Your Worship, it is also admissible that indeed the accused person, there is no likelihood that he will interfere with witnesses in this matter, Your Worship. Firstly, because, Your Worship, according to the state, the witnesses that will be testifying against the accused person, they are unknown, Your Worship. The state did not provide us with any list of witnesses that these are the people that will be testifying against you. And the accused person, Your Worship, will not go around on the street and asking people that who will be are you going to be testifying against me or you will not be testifying against me, Your Worship. And Your Worship, we submit that the state has not established any ground in terms of section 60, subsection 4, A to E, Your Worship. Your Worship, there is no likelihood that the accused person will commit any speaking one offense. Firstly, because Your Worship, from the previous conduct of the accused person as per the SAK 69, there is no any proof, Your Worship, indicating that the accused person has any history of violence, Your Worship, that is supported by any case that was previously opened against the accused person or any domestic or harassment order that were granted against the accused person, preventing him, Your Worship, not to assault or do anything to anyone, Your Worship. Your Worship, we understand the submission by the state that they fear that there are other children, Your Worship, that will be in danger to the accused person being released out on bail. Your Worship, the accused person has been residing in the same address for the period of 10 years. No complaint or anything has been reported to the police. And Your Worship, there are other children in that house, Your Worship, even the neighbor's children, that has nothing happened to them, Your Worship, until this alleged incident that brought the applicant before this court, Your Worship. Your Worship, we also submit that the accused person will not evade his trial as we previously indicated. He is employed, Your Worship, and he has been employed at case 6 months for a period of at least a year, Your Worship. It shows, Your Worship, that he is stable in his employment and no likelihood, Your Worship, that he will leave his job, Your Worship, and try to evade the trial against him, Your Worship. Your Worship, the accused person will not be a danger to the community. And that his life should be released out on bail, Your Worship, will not endanger his life, Your Worship. Your Worship, we have posed a question to the investigating officer indicating to him, Your Worship, that the accused person in the holding cells will not be safe, Your Worship. And Your Worship, the investigating officer did not dispute that. We considered with us, Your Worship, that indeed to be kept in custody, then there are likelihood, Your Worship, that may be in endangered. The only Your Worship says that there are police officers, Your Worship, that are responsible to take care of the inmates, Your Worship, that the accused person in his affidavit testified before this court, Your Worship, informing the court that he had reported the incident to the police, but they did not take any actions, Your Worship. Your Worship will also submit before this court that should the court release the accused person out on bail, Your Worship, this court will not be undermined. We submit, Your Worship, because, Your Worship, it is the duty of the police officers and other stakeholders to inform the community, Your Worship, about the bail process. The bail process, Your Worship, they should clearly understand that we are not saying the accused person is guilty or not, but we are saying, Your Worship, that the accused person should be released out on bail, Your Worship, that he attend his trial while he's out on bail, Your Worship. Your Worship, we submit further that, Your Worship, the accused person has already indicated before this court that his life in custody will be in danger, and further that, Your Worship, it is not in dispute, Your Worship, that our holding cells as well as the prison cells, Your Worship, are overcrowded. And we submit, Your Worship, that the accused person should not be granted it should not be denied an opportunity to be outside, Your Worship, looking at the fact that the positions of the holding cells as well as the prison cells, Your Worship. Your Worship, we submit that should the state come before this court and inform the court that they are opposing bail, Your Worship, in terms of section 60, paragraph 4E, read together with subsection 8A, Your Worship. We request, Your Worship, that this honorable court, Your Worship, should proceed with caution in establishing that the requisition, the first thing the court does need to establish, Your Worship, is that the interest of justice permit that the accused person be released out of bail. And, Your Worship, we submit that indeed it does, the interest that accused person be released out on bail, Your Worship, outweighs the section 4, subparagraph E, as well, section 60, subparagraph 4E, as well as section 8, Your Worship, 8A, capital letter A, Your Worship. Your Worship, we further submit that, Your Worship, the accused person is entitled to the 2 remaining children that he left with, and, Your Worship, the interest of children still exists even in this case.
And is the mother of those children employed?
She is unemployed.
Unemployed.
Yes. So the interest of justice, Your Worship, still permit the the interest of justice of the interest, Your Worship, of the minor children in this case is still applicable, Your Worship. Your Worship, we submit that they should be considered at this stage, pending, Your Worship, the finalization of this case, and for the court, Your Worship, to decide whether the accused person is guilty or not guilty, Your Worship. Your Worship, we have listened to the testimony of the witness of the state, Your Worship. Your Worship, he was just narrating a story to the above honorable court of what have allegedly happened in the state, Your Worship. But, Your Worship, with regards to the factors of section 66, paragraph 4-8, I honestly submit before this court, Your Worship, that I had to go and look for what the witness wanted to establish or inform the court of the reason why the court should, when exercising its discretion, deny the said applicant bail, Your Worship. Your Worship, he was proceeding as if this is a trial, that we are in a trial, Your Worship, and the accused person has really did it, and bail should be denied on that fact, Your Worship. Your Worship, we further submit that Your Worship, as it was said in the case of S, this is Dlamini, Your Worship, that Your Worship, the court said that bail served not only the liberty interest of the accused person, but that the public interest by reducing the high number of awaiting trial prisoners, clogging our already overcrowded correctional system, and by reducing the number of families deprived of breadwinners, Your Worship. Your Worship, we have already made submission with the said case, Your Worship. And Your Worship, we submit that, as it is said in the case of Sambo versus the state, Your Worship, the court, the Northern Cape High Court, Your Worship, in this case informed, it wrote, Your Worship, that The fact that the investigating officer is submitting evidence, Your Worship, but those submissions are not supported by any evidence, Your Worship, then that evidence lacks probative value and it should not be relied on. That was in Sambo. This is the state, Your Worship. Your Worship, with this statement, we are informing the court that the investigating officer came before this court and is adamant, Your Worship, that the state, that the communities, they will be shocked, maybe outraged, Your Worship. That I'm just going as the way he was testifying, Your Worship. I'm the opinion that he was trying to say that, Your Worship. So, Your Worship, we submit that he did not bring any proof to that effect. There was no petition from the community. There is no demonstration before this court, Your Worship, indicating the same. He did not even tell the court, Your Worship, that the people that are in the gallery, Your Worship, are here to oppose the bail application of the applicant, Your Worship. It is my submission, Your Worship, before this court, that, Your Worship, the family of the accused person, Your Worship, are the one who are in the gallery. They are the one, Your Worship, who are here to support the applicant, Your Worship, and that he be released out on bail, Your Worship, for them to, he indicated, Your Worship, that his mother is unemployed, and he indicated that he support the mother as well, Your Worship. So the mother is before court, Your Worship, to see what would happen to the breadwinner, Your Worship, pending the finalization of this case. Your Worship, it is our submission that should we come before this court as the applicant and the defense attorney, telling the court, Your Worship, that this crime is not shocking or this crime is not something unusual, Your Worship, will be like, we understand, Your Worship, that these allegations are very serious. Understand that this allegation, Your Worship, hardly happened where there is the father or the stepfather as a statement. We're keeping on referring, even after when the applicant has said that he is he regard the child as his child, Your Worship, living on his abdomen, will be lying that it's not something unusual, Your Worship. But we humbly request, Your Worship, that he be released out on bail, Your Worship. It is for the trial court, Your Worship, to establish whether the accused person is guilty of the charge against him or is guilty of anything or not guilty of anything, Your Worship. So with this submission, Your Worship, we humbly request that bail be granted, Your Worship. Your Worship, when it comes to the amount that should be granted against the accused person, Your Worship, we humbly request the court, Your Worship, that the court look at the fact that the accused person is earning 6,500 per month. They does not have any other income or any other things, Your Worship, any other business except this one, Your Worship. So we humbly request, Your Worship, that bail be fixed in an amount of at least 1,000 rand, Your Worship, as per his damage. Your Worship, we also submit that in the case of LGC Statution, Muhammad J. said, Your Worship, that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of law, Your Worship, is that he is innocent until his guilt has been established in a court of law. The court will therefore ordinarily grant bail to an accused person unless likely to reflect the end of justice. Your Worship, we humbly submit that the end of justice, Your Worship, will not be prejudiced in this case because, Your Worship, the state as we stand here, they failed to establish any grounds listed in terms of section 60 subsection 4 to E, together with the other sections, Your Worship, section 5, 6, 7, 8, and 9 of the Criminal Procedure Act, Your Worship, and that, Your Worship, bail on the accused person should be granted and not so overwhelmed, Your Worship, on the fact that the investigating officer of the state, Your Worship, came and narrated a story but not properly laid out the basis in terms of section 60 subsection 4 to the Your Worship.
Thank you, Minister.
bopaki mo lefapheng ebilane gape kgang ya gage ke gore wena ga gona di-protection order kgotsa di-order tse e leng gore di go kgatlhanong le wena gape wena ga ona dikgetse tse e leng gore di la bona molatong wa tsone gape a re wena ge motho o leng gore wa bereka ebilane ba ko lapeng ba itsegile ka wena wena e leng gore wena o ba fepang ko lapeng a re ge o kopile le melawana ge mone a re molawana wa section 60 wa section 60 paragraph 4 a to b ga ba tlhagisa ba botsisitse gore wena o ka se moteng ka teng a re mo caseng ya gakanene go tlhagisitse gore goreng batho ba ka mele ka lekolo ka beile ka gonne batho ba seke ba tshwarwa mo diseleng e le bone ba e leng gore lapa la bone ba ipegile ka bone gape a tlhoka gape a lokola gape le mo caseng ya gasambo a re mothuthuti o biditse lepodisa le le tshwereng kgetse ba lepodisa le le tshwereng kgetse lone le tlisitse story se e leng gore se etsagetse a tlotlela le go tla gore se etsagetse na a sa fane ka mabaka gore ba se letsele ka gone.
This matter is postponed until the 3rd day of July, this coming Wednesday, for judgment. You remain in custody, sir. Oh, what time is it?
Yeah, you can request to postpone for address. I would also like to respond, Your Worship. I had the response, but then they want to go and prepare an outside.
Yeah, but then you had a choice. But I'll give you a very long rope, man, to hang yourself. This matter postponed until the 3rd day of July for the state to address and also for this court to deliver judgment on bail. You remain in custody, no bail. Thank you, sir. Are we still left with another case? Is that the role?
That is the role, Your Worship.
Yeah, court agents, everyone is excused.
This is the court, Your Worship. The state is calling case number D794/2024. The state versus the Applicant Edward Moirang. On the record today is the 3rd of July 2024 in the Magistrate District of Rustenburg. The court composition, presiding officer Mr. Diale, public prosecutor Mr. Makalan, the interpreter is Mr. Marcela, our stenographer is Mr. Tasedi, the accused is represented by Ms. Tumbe. The matter is controlled today with the respondent's argument as well as judgment.
On the last occasion, I didn't give you enough opportunity to address me. You did it in a rush. You still want to go through that address, or the things that you want to add in your address that with me. Remember, you requested time to also prepare.
Your Worship, maybe there's only one thing that we need to address the court, Your Worship, or only one, Your Worship, and if the state address and there's anything, we'll reply, but if there's nothing to reply to, Your Worship, we'll not reply. Your Worship, we wanted to address the court on the court previous occasion, posed a question on the issue of the appellate. Your Worship, maybe the wording was wrong. After consultation with others, Your Worship, I was informed that the proper word is accepting the worship. Sympathy, to sympathize or to, yeah, but not to apologize per se, worship. So that's what we wanted to add the worship and to correct, should we be granted an opportunity to amend what they have done, worship. But other than that, your worship, those are our submission. If the state make their submission and there's anything to reply to, then reply. If not, your worship, then that will be it.
Thank you.
As it places the court worship in closing argument for the respondent's case worship, this bail proceedings worship are governed by section 60 subsection 11b of the Criminal Procedural Act worship, and the said section worship places an onus on the applicant to adduce evidence to the court as to why it is in the interest of justice that he should be placed on bail.
Tsamiso e re ya bobega bina tsamiso la molawana section 611b o ra gore o mo boshušhising ya ka ba go latofatsa tshwanetse le ba tlhagise mabaka a bona gore goreng ba go latofatsa ebile go wena gape o mo magetleng a gago gore o tlhagise bopaki ka mabaka a ikgethang gore motho maleba gore ka tsela pele.
This worship was also reaffirmed in numerous cases. In one of the cases worship, it is the case of S versus Lamini worship, which was stated by my colleague during arguments worship, where the Constitutional Court stipulated that an accused must satisfy a magistrate that the interest of justice permits release. It clearly places an onus upon the accused to adduce evidence.
Ke kgatsi ya bogologolo boshušisi bo sekisana le tlameng e moedi wa gago le ene ana e tlhagisitse lene le gore ba re mo kgetseng ya teng go mo magetleng a gago tota gore tlhagise mabaka a ikgethang a tla dumelang le dikgatlhego tsa bosiamisi gore motho maleba go ka tsela.
Worship, this simply means that there is no duty placed on the state to adduce evidence as to why the accused should not be released on bail in instances where the accused had failed to prove his case.
Jaanong ga go mo boshušising gore bona go tlhagisa bopaki ba bona ke wena fela motho o tsayang a tshwanetseng a tsene ikarabelo wa gore o bontshe tota gore dikgatlhego tsa bosiamisi di yang go maleba gore ka tsela pele.
This is an application of the accused to the court, and worship, the applicant cannot come to the court and say that the state failed to prove this and that during his bail application.
Jaanong o ga gona gore kgotsa a re ga gona gore wena o ka re mo go bone bona ba paletse ke go tlhagisa mabaka a bone mo kopong ya gago ya pele.
My worship, the applicant in his bail application read evidence by means of an affidavit.
O tsentse kopo ya gago ya pele ka tsela ya go kwala affidavit.
Worship, it is a well-known rule by this court that viva voce evidence weighs more weight than an affidavit.
Mo kopong ya bail pati jaaka ditsela di fapana go na le tsela e o dirileng ya go kwala affidavit e go nna le ya gore wena o namela boxo ka fa tsa bopaki o bua wena dintlha tsa gago ka boena ba re eo ke yone e leng gore e na le boleng tota go feta ya.
This worship was held in the case of S versus Pinar. This worship was held in the case of S versus Pinar, which is a 1992 case of worship, and the court gave reasons as to why viva voce evidence weighs more weight.
Tlhagisitswe go kgetseng ya 1992 ga o sekisana le Pinar ba tlhalosa yona kgang ya gore goreng ba re ga o le ka bopaki bo fanang ka bona o le mo maikanong ke bona ba boleng go feta ba affidavit. O tla utlwa ba re
Worship, the court held that the evidence in the form of an affidavit is not open to being tested by cross-examination, and as such is less persuasive.
Lebaka ke gore ba re ga o kwetse ya affidavit ga gona gore boka jaaka e le ya gagwe bone ya ka bosekisi ga ba kgone gore ba botsolose ba botse seo se se kwetseng ba dipotso ga go sa tshwanela ga o le ka o fana ka bopaki ga o fetse ba go botsa bopaki ga sona.
The court further held that viva voce evidence weighs. The court further held that viva voce evidence which is tested weighs more weightage.
Ga o fana ka bopaki ka bo wena le wena o buang ke bona bopaki ba boleng bo ile go tota ba utlwana.
My worship, this is important in this case, worship, and the state is not just mentioning it, worship, for the sake of argument, but it is important because there is information in the affidavit which, worship, was handed in by the applicant.
Go na le dintlha mo affidaviteng ya gago e leng gore ke o tsenya kopo ya gago ya beili mo go yona e amogetsweng jaaka bopaki mo tsamaisong ya beili,
Which worship, I believe the court deserves clarity on.
mo ntlheng eo ge mosekisi buka gore go tshwanetse le go nne le tlhaloso mo kgeng e o ikotseng mo affidaviteng.
Worship,
Nothing was said as to the circumstances leading to the allegation. You just said they are going to tender a plea of not guilty.
yes, worship, I will come in to address that issue. God bless you, worship. As the court has indicated that one of the issues was that the applicant indicated that he will be tendering a plea of not guilty, worship.
Mo affidaviteng ya gago ge o tlhagisitse lebaka la gore wa wena mo nako
Worship, this is despite the serious charge that he is facing. There is no version of the accused placed to the court. Despite the serious charge that the applicant is facing, there was no version of the accused which was placed to the court.
le ga gona o lebagane le tatofatso e ne bofile mo kana ga gona letlhakore la gago le leng gore lona wa le tlhagisa mabapi le tatofatso.
And Your Worship, as a result, how is the court supposed to know that the accused has chances of being acquitted in this matter?
Yaanong lekgotla le tla itse jang ge gore go na le gona gore o ka se bone le molato o tlogetseng.
And Your Worship, as it stands, the state is the one that placed its version through oral evidence, and the defense was given a chance to cross-examine the witness, Your Worship, and it was not challenged.
Jaanong bosekisi ke bona ba e leng gore bo tlisitse bopaki ba bona ka pakeng ba ka mo e leng gore ga ba fetsa bopaki bo ga ba ka ba botsoloswa.
As it stands, Your Worship, the state has a very strong case against the applicant, and chances of conviction are very high.
Jaanong jaaka e le bosekisi ba re kgetsi ya bone kgatlhanong le wena e ne mofile thata mo e leng gore go na le kgonagalo ya gore ka bona o le molao.
Now, Your Worship, the other issue with regards to the applicant's affidavit, Your Worship, was the issue of the applicant indicating that he wants to be released on bail in order to apologize to the family of the deceased. However, Your Worship, I believe that was verified.
Yes, he wants to see. He wants to, I don't know, still
To
sympathize. How do you do that? Approaching the family and say, I'm sympathetic to your cause.
The issue is that the child that lost his life in this case, which was the child that has been residing with the accused person for plus 10 years, which we also accused it in our affidavit. So the allegation cannot come before you and they say that you killed someone or you were involved in the killing of someone, and you just keep quiet. You don't even say, but I'm sorry. To say someone lost their life, it's not like when you're stolen in the shop and a child lost his life and the child was staying with the said accused person.
I understand that part, but that aspect was not even put in the affidavit. That is disposed.
The 10 years.
The whole issue that he's saying is sympathetic, or he wants to just explain as to what really happened. It's not there in the affidavit. It's not there even in your address.
Your Worship, in the affidavit we mentioned that the accused person would like to be released. That's the first line. If they're released so that you can pass the condolences to the family as well as to sympathize with the family.
But that is not answering the allegations, isn't it?
Your Worship, but the issue of allegation will address the court that the entire court will be then the one deciding that.
So this court cannot look at the strength of the state case.
Your Worship, at this stage we did not challenge the strength of the state case. That's why we were going to reply to the state, or can we reply now, Your Worship?
No, just aspect. Let him finish and then
Yes,
you
Your
reply.
Worship, court proceeds.
Thank you.
Mo dikgantseng tse di buiwa fa gae ke gore o shišisa le rena botleletse go na le ntlhanyaneng go gana simolola tlhaiso go na le ntlhe nngwe mo affidaviteng ya gago e le gore o tlhoka gore le tle le tlhalose sentle mo pela le go tlha ke kgang e le ya gore le le kwetse gore le batho kopa maitshwarelo ko lesiking la ngwana o latlhetswe ke bophelo ba fela moeledi wa gago a ba e tlhalosa gore ne re sa re kopa maitshwarelo fela re kopa beili ka lebaka la gore re batla go ilollisana le family ya ngwana o latlhetswe ke bophelo ba gagwe ka o no phela le ene dijara tse disome tse di fitileng.
Court basis, Worship, this is the, I don't know whether, Worship, I should say the consequences of using an affidavit, Worship, because the court, Worship, is left with an evidence, Worship, which was not tested, and some of the aspects, Worship, are not clear as to what exactly was the applicant trying to say, Worship. It is not only that, Worship, which was mentioned in the affidavit of the applicant, Worship.
Ga seo fela ge se se tlhagisitsweng mo affidaviteng ya gago se ne se tlhoka tshedimoso sentle a re go ntsinyana.
The applicant, Worship, went further in his affidavit and stated that he did not plan to cause the death of his son. It was an unfortunate incident.
E ne se maikaelelo a gago a gore o tlhole leso la ngwana wa gago ke tiragalo fela ge e ne e na le madimabe wa gore ngwana ba feletsage.
Worship, I'm not sure if the applicant was trying to make some admissions in that affidavit, Worship.
Jaanong mosekisi fa le ba ka yona ntlha eo fela ga a tlhaloganye sentle gore a go na le kamogelo o ne o batla go e dira.
Are you saying he wanted to tender a plea of what do you call culpable homicide?
And Your Worship, I'm going to reply to that. And if Your Worship, they want to bring that thing, then it changes the whole schedule.
Yeah, let him finish submissions and we'll give him opportunity.
Worship, doesn't necessarily mean that he is trying to tender a completely uncapable homicide, Worship. Remember, there is premeditated murder, Worship, and there is murder, Worship, where he does not collect, Worship.
Yeah, no. Go tsena go tla yone ya ka ntlha gore wa re o ne e ne seng mo maikaelelong a gago a jaanong go tswa go tsena go tla yone a jaanong o batla gore e ne le ke go bolaya motho a nna sa ikemisetsa go bolaya a re go na le gore motho o rulaganya gore yo bolaya le gape go nna le bolaya.
Fortunately, Worship, at this moment we will never get that or the answer, Worship, because the state was not given an opportunity to cross-examine the evidence of the applicant, Worship.
A re no go baemeng go teng gona no ga ba kgone gore ba ka thusa ntlha eo ka botlalo ka ntlha gore ga ba kry-a tšhono bone ya ka bosekise gore ba ka botsa dipotso ka bopaki ba gago.
Now, Your Worship, the state has submitted to the court that the accused should not be released on bail on the basis that there is a likelihood of him intimidating or attempting to influence the witnesses.
A re jaanong ba ganetsana ka kopo ya gago ya beili ka mabaka a reng go na le kgonagalo ya gore tla re ga o tlile ka beili go tsamaya o ile o tshosetsa dipaki kgotsa o tlhotlheletsa dipaki ka tsela e nngwe.
Also that the offense which has been committed and the circumstances under which it was committed has induced a sense of shock, not only to the community where it was committed, but to the country as a whole. Hence, we have the media people today.
A re ge tatofatso eo le gane le yone raga ya ke eno mofileng tota mo e leng gore ga ya tshosa fela setšhaba sa tikologo eo e thusitse naga ya rona e otlhe ka bophara ba yona ke ka moo ka tle ke yang mo e le goneng re iphitlhelang re na le basetegeniki
ba tegeniki ba tshwantshisa tsamaiso.
The applicant is accused of murdering his stepson, and as per the evidence of the investigating officer, the offense was committed in a previous manner.
Arta do ba tloga la o le bagane le yone ke a go bolaya stepson sa ga mo ile gore ga tiragalo e o diragetse ka setlhogo.
The community worship gathered at the place of residence of the applicant where the offense was committed, and they were not pleased with what the applicant had done.
Setšhaba ga sa le o se sa go kwana go tiragalo tse diragetseng go teng ebile ba sa bontse mmego.
If the court grants the accused bail, what message is it sending to the public?
Ga le kgotla le ka go fa bail ke molaetso o feng o leng gore le kgotla le tlabe le o romela go setšhaba?
We submit that the release of the applicant on bail will undermine or jeopardize the public confidence in the criminal justice system.
Setšhaba kwa ntle se se sa nna le tshepo mo bosiamising.
On the issue of applicant intimidating or influencing the witnesses, worship, we would like to submit the following.
Ka kgang ya gore ba re ga o tsile ka pele o tla tshosetsa dipaki ba tlhagisa dintlha tse di latelang.
Worship, the applicant has no alternative address. The witnesses are his neighbors as well as the mother of the deceased, who is also the girlfriend of the accused.
Kgotsa dipaki ke baagisane mmogo le ngwana wa mamago ngwana o tlhokafetseng ebile le kgarebe la gagwe.
And the investigating officer, during his testimony, confirmed that the mother of the deceased was interviewed and the statement was obtained.
Letseka le le tshwereng kgetse ya gagwe le le batlisisang a o nnile le dipuisano le mamago ngwana o ebile statement sa gagwe se tsene.
And the defense cannot submit to the court that the state did not provide them with the names of the witnesses.
Jaanong wena le mmoledi wa gago le ka sekelane ga la fiwa maina dipaki.
And one of the witnesses is also a victim of the applicant's violent conduct, and his name was mentioned in the court as the accused is on count 2 of assault.
Nngwe paki ke motswa setlhabelo mo tshotlakakong e ke le itemogela yona kgatlhanong le wena e leng gore leina la gago le ene le kwetswe mo tatofatsong e ya bobedi ya bobedi.
The other witness in this matter is also known to the accused because the applicant sent a message to him that the child is not within worship after committing the horrible crime.
Paki nngwe ge le yone ke e nngwe le gore e tlhagi. Apologies, worship. Can I get the witness said to me?
No. The other witness is known to the applicant because the applicant sent a message to that witness informing him that the child is not breathing.
Paki nngwe ge a re le yone wa itse ka paki e leng gore wena o e boleletse gore ngwana ga sa tlhalane.
And as a result, these witnesses are well known to him. We further submit that the defense cannot say that since his arrest, he has not attempted to intimidate them because he is in custody and he has limited access to
Argasa le ge o le mogolego kgotsa ga ise o tsamaye o leke go tshosetsa dipaki tse ka ntlha gore nako yotlhe morago ga ditiragalo o ntse le go kgolegeng yaanong ga o kgone gore ka ba fitlhela.
One of the factors that the court needs to consider in determining whether there is a likelihood of the applicant influencing or intimidating the witnesses is mentioned in section 60, subsection 7D.
E nngwe ge mo tsa semolao mo e leng gore ba tlhagisa fa le gore go na le kgonagalo ya gore o ka tshosetsa dipaki e kwetswe mo molaotheong mo section 60 subsection 17.
Worship is the relationship of the accused with the witnesses and the extent to which they could be influenced or intimidated.
Ke kamano ge o nang le yona le kgotsa ke kamano ba nang le yona le wena mo e leng gore ge fa kgonagala gore o ka ba tshosetsa ka ntlha gore ke batho bao ba itseng le wena ba kgona.
It has already been mentioned, worship, that the witnesses are well known to him and he also has their contact details.
Wa laitsane wena le batho ba ebile o na le ka mokgwa ka kgolaganang le bone ka mogala wa letheka o na le dinomoro tsa bone.
Of most importance is the mother of the deceased, who is the girlfriend of the accused.
Se se leng botlhokwa kgotsa kgang engwe e botlhokwa thata e leng mamago motswasetlhabelo o.
Not only is she the girlfriend of the accused, but they share 2 other kids.
Ga se le kgarebe la gago fela le na le bana ba le babedi wena le.
And worship, this is a person who seems to have neglected her parental duties, worship, to the deceased, and she seems to be very fond of the accused person.
A re mama go ngwana o ke motho e leng gore ge o ikgatholositse maikarabelo a motsadi ngwana ba latlhegelwa ke bophelo ba gagwe ebile a tlhagelela gape yaka motho e leng gore o go rata e le ruri go ntse go ntse jang.
Can you please switch off your phone or go outside?
Bagolo kopa re timeng megala a rona ga e le gore ga o itima le tsa modumo tswela ba ntse o itima.
Tell me, on that aspect, what is your submission regarding the fact that the accused person is gainfully employed and you also support the 2 remaining minor children and that their mother is unemployed?
Your worship, the accused person has been in custody, your worship, since the 21st of June, your worship, 2024, your worship, and we have never heard of anything, your worship, of the mother of the accused struggling, the mother of the deceased, your worship, struggling to maintain the other kids, your worship, and I also believe, your worship, that there are social grants, your worship, which can assist in this matter, your worship.
Go tlhale le tlhoka tlhaloso ge mo ile gore kana wa dira jaanong bana go diragala jang ka bona ga ise go nne mo ga ise go tlhakganya ya gore ga o tlhokomele bana ba mo go le mme wa bona jaanong mosikisi a re salo le go kgolelelong go simolola ka 21 tsa June 2024 go fitlheng ka jeko yana ga ise go tlhakganya gore mama go bana ba le ngwana le bana ba sokola ka tsela e rileng gona gore ge ba phela sentle ebile le madi a bona a grant a ka ba thusa.
And also, we cannot just turn a blank eye on the offense which was committed by the applicant on the basis that he is supporting the kids. It cannot just be ignored by the court.
A re kry gape re ka se re ikgatholosa kgang ya molato o nonofo ya molato o re lebeletse fela gore wa dira o sapota bana a re kgang eo ga ra tshwanela gore re itlodise matlha gore o sapota bana mara molato ke eo ebile o nonofile.
And worship, as there's already been mentioned by the state worship, if you look at the relationship between the applicant and the mother of the deceased worship, the chances of the applicant influencing the mother of the deceased worship are very high.
A re bile gape ge re lebelela kgetsi ena yona gape ka bo yone paki e leng mama go ngwana go wena le ene le sentse le utlwana mo e leng gore go na le kala gore ga o tsaka pele o kopana le ene le bua le ka bua ka kgetsi eo o leka gore o mo tlhotlheletse ka tsela e rileng gore di kgetsi.
And Your Worship, as a result, we submit that the applicant has failed on his duty to prove to the court that the interest of justice permits his release on bail, and that bail should be denied to Worship.
Ya nombara fe kala khona wena le moedi wa gago gore re tlhagise bopaki ba lona ka botlalo ka mabaka e kgethang gore motho o maleba gore ka fiwa beili jaanong bone le bosekisi ba re o timiwe beili.
Your Worship, I want the long just through Your Worship, the submission by the state that we adduced evidence by means of affidavit, Your Worship, and they were not granted an opportunity for them to test such evidence, Your Worship.
What time is the tlhagisa bopaki ba lona ga ya tsela ya affidavit mo e leng gore bosekisi ga ba kry na ya gore bo ka ngangisa bopaki ba lona?
Your Worship, in the case of Molebangwe, it's case number A212 of 2021, and the High Court that heard the matter was...
You say S versus Mufukeng?
My apologies, Mufukeng versus the state. It is an appeal, Your Worship, against the refusal of bail.
Yeah. And then the citation?
It's A212/2021. They are in brackets, Your Worship, in brackets. Then ZA GPP HC 522/2022. The judgment was issued on the 12th of August 2022, Your Worship. Your Worship, the court at paragraph 7 said, Section 60(11)(a) prescribed that an accused person must adduce evidence when a bail application is brought in terms of the said section. Evidence can be adduced by either viva voce evidence or by the means of affidavit.
We rasigaige ka khetsa mogologolo fa ya 2022 ga ne bosekisi na le Mofokeng kwa e court kwa ba re judgment ya teng e tlhagile ka di 12 tsa August 2022 ba ga mo tato kopo ya bail e tsamaisiwa ka molawana wa section 60(11)(a) di tsela di pay ya go tsamaisa kopo eo ya ntlha ile ya affidavit ya bobedi ile ya wena le motse ba falofana go fa.
And Your Worship, we want to continue from what we submit by this statement, Your Worship, that the accused person have done what is required of him. He adduced evidence by a means of affidavit.
Jano o dirile sene kgotsa se molao o se buang o pwetse kopo ya gago ya bail ka tsela ya affidavit.
And Your Worship, in the case, the famous case of S versus Matebula, Your Worship, the Supreme Court now, when Matebula was appealing, saying that Matebula adduced evidence by means of affidavit, but in his affidavit, Your Worship, he was challenging the state case, saying the state case is weak, but there was no any evidence that he used to substitute to the statement that the state case is weak, Your Worship. Then the court said no, but Matebula cannot come and say the evidence of the this was in 20. I'll provide a citation, Your Worship. It was in 2020, Your Worship. I'll provide the citation before we go further.
I do have the citation.
Court, this is Your Worship. Thank you, Your Worship. And the Supreme Court said, Your Worship, but Matebula cannot come and say that the state case is weak because he himself adduced evidence, and the evidence was not tested. Then it means his affidavit is less persuasive. So we submit, Your Worship, that each case must be treated on its merit, just like this case where the Supreme Court of Appeal said, yes, your affidavit is less persuasive because you are saying the state case is weak. So you were supposed to put in details that I will be acquitted, they did not find me, ID parade was not held, and all those things. Then the state can question you if they want to seek clarity, Your Worship. But in this case, Your Worship, the accused person adduced evidence, he informed the court of the reasons why he wanted to be released out on bail, and he did not go to the state case or anything. So the state cannot come and say, we want to challenge that. What did he mean by him saying he wants to apologize or he did not plan anything, Your Worship. That now we will be proceeding with a trial.
No, I understand, but isn't it the honors of the duty based on him to prove on the balance of culpability that the interest of justice requires his release?
Indeed, Your Worship. And we submit that this person...
So it means he needs to satisfy me.
Indeed.
That is a candidate to be released on bail.
Indeed, Your Worship.
He must take me into his confidence in doing so. Did he manage to do so?
Your Worship, he managed to do so. And Your Worship, we... just one last thing, Your Worship, the state, I want to reply because the state keep on saying that the accused person will influence the mother of the child. Your Worship, we know that accused persons are granted an opportunity to contact their family members and be in contact with them. If he wanted to, Your Worship, he would have done that during that period, during all this period, Your Worship, to influence the mother of the child. Further, that Your Worship, the state says they mentioned something about the premeditated murder as well as the murder, Your Worship. Your Worship, we did not want to argue this because at the end of the day it will not take us anywhere. We are not disputing the schedule. But if they keep on making this submission, we will submit, Your Worship, that this is then Schedule 1 because the testimony of the investigating officer confirmed that this person was reprimanding the child and the child then passed on in the process. Then we shouldn't be proceeding as a Schedule 5, Your Worship, if they want to maintain it.
I mean, I believe that will be moot. Why I'm saying so is that before we proceeded with this application, I have asked and you answer that this is Schedule 5 appeal.
Yes, Your Worship.
For now to come and say, in fact, looking at the fact, this is Schedule 1.
Your Worship, I remember when we start, we don't know the facts. So when they come and present the facts, that's when we now, and they want to change. No, this is premeditated. You will do what? So they want us to say now this is a Schedule 1.
No, you were just saying there are different types of men.
God please, Your Worship, I might have missed it.
Because if it's premeditated, it will be facing the Schedule 6.
God please, Your Worship. Your Worship, I missed that submission. I thought maybe he's saying that. No, God please, Your Worship. We have no further submissions.
I believe a lot has been said by both the state and the defense. It also requires me to go and look at the case law that has been submitted for me to consider my decision whether to release accused or not to release accused.
Yeah, no. Le kgotla le utlwa gore nya tota moedi wa gago le boshushisi ba buile go tlala seatla ebile ba dira dikai ge ga dikgetse tsa bogologolo tse neng gore le kgotla gona no nya magistrate o tshwanetse a ile o utlwelela sentle a bale dikai tse ntse ba di bua morago ga gore a tseye tshwetso ya gago.
And for that reason, I'm not going to rush today to deliver the judgment. I feel it's only fair for me to postpone it again, final for judgment. It is coming Friday.
Jaanong ka ntlha gore go ntsi ge magistrate a ka se ka kgona gore a tseye tshwetso ya gagwe gona nonyana dibala ba tsaya tshwetso. Seo se raya gore kgetsi ena tshwanetse le busediwe morago gore tlo utlwa gore a beidi wa e kry-a kgotsa wa e kry-e ka la botlhano rango.
And it also assists you that if I refuse to bail, then we'll have all the reasons to go to the High Court to appeal for bail. Or whoever is aggrieved.
Ebile e tlo go thusa kgang eo ge gore ga e le gore ga o e kry-e bail e tlo go fa napa gore o tsama o yo appeala ge go High Court opa.
Not a postpone until the 5th day of July for judgment, meaning custody and of bail.
Kgetsi ge e tla busediwa morago tla ka di-5 tsa July gore tlo utlwa gore a beilwa e kry-a kgotsa o kry-a. Is an application from the accused?
May I approach you?
Yes.
Your Worship, there's an application from the accused person. I am going to request, Your Worship, that if he can be removed from the police cells, Your Worship, and be maybe taken to prison or
Worship, as you have alluded, Your Worship, that the conditions there are not bearable, Your Worship.
Well, unfortunately, I cannot train there, and the reason is one is that I can only move him if maybe his life was in danger or something, but not because of the condition, because all of them are subject to the very same condition. So why should I treat him differently?
God bless this Worship.
Court agency for
All right. No.
Yeah.